General Kagan.
Mr. Chief Justice, and may it please the Court, I have three very quick points to make about the government's position. The first is that this issue has a long history. For over 100 years, Congress has made a judgment that corporations must be subject to special rules when they participate in elections, and this Court has never questioned that judgment. Number two.
Wait. We never questioned it, but we never approved it either. And we gave some really weird interpretations to the Taft-Hartley Act in order to avoid confronting the question.
I'll repeat what I said, Justice Scalia. For 100 years, this Court, faced with many opportunities to do so, left standing the legislation that is at issue in this case. First, the contribution limits, then the expenditure limits that came in by way of Taft-Hartley, and then, of course, in Austin, specifically approved those limits.
I don't understand what you're saying. I mean, we're not a self-starting institution here. We only disapprove of something when somebody asks us to. And if there was no occasion for us to approve or disapprove, it proves nothing whatever that we didn't disapprove it.
Well, you're not a self-starting institution, but many litigants brought many cases to you from 1907 onwards. And in each case, this Court declined the opportunity to invalidate or otherwise interfere with this legislation.
But that judgment was validated by Buckley's contribution expenditure line. And you're correct if you look at contributions, but this is an expenditure case. And I think that it doesn't clarify the situation to say that for 100 years, to suggest that for 100 years we would have allowed expenditure limitations, which in order to work at all have to have a speaker-based distinction, exemption from media, content-based distinction, time-based distinction. We've never allowed that.